Welcome back, gang, and thanks for being with us tonight. It's been just over 24 hours since former President Trump spoke for the first time since his arraignment. In remarks last night, Trump defended himself and attacked Jack Smith, the special prosecutor who Attorney General Merrick Garland assigned to the documents case. It may be a glimpse of one of the many ways Trump's team might try to defend him. Today, Garland defended his decision to put Smith on the case.
As I said when I appointed Mr. Smith, I did so because it underscores the Justice Department's commitment to both independence and accountability. Mr. Smith is a veteran career prosecutor. He has assembled a group of experienced and talented prosecutors and agents who share his commitment to integrity and the rule of law.
Now I want to bring in constitutional attorney Andrew Lieb. Andrew, thanks again for being with us tonight. I feel like every time you're here, we're building on the knowledge that we got from you the last time. So let's see if we can move it forward even more. We heard a lot from the former president yesterday, including references to other investigations, including investigations with Bill Clinton, Hillary Clinton, Joe Biden, and at one point challenging the legality of the investigation into his possession of the documents, specifically the FBI raid on his Mar-a-Lago home. You were with us last night, and you said the former president tried to sound like a lawyer during your speech. What does this reveal, if anything, about what kind of case his defense might lay out?
Christian, we heard three different themes during the former president's speech at Bedminster. We first heard the whataboutisms, where we said, what about Clinton? What about Biden? What about these people? And that first defense plays very well, Christian, in politics. But in a courtroom, it's not even going to get to the jury based on a concept called relevancy. Yes, it's possible that Trump's attorneys can move to dismiss, arguing selective prosecution, but I think that's a nowhere train. The second thing we heard from Trump is about unreasonable search and seizures, the Fourth Amendment. And typically, that might be something that we'd be wanting to explore. You see, you might say, hey, was the evidence submitted to the judge for the subpoena flawed? And maybe it was. And in discovery, Trump's team is going to be able to go through it. But as you were just showing in the Garland speech about Jack Smith and his team, these are the cream of the crop experienced prosecutors, and I would doubt they would mess up an application for a subpoena. But if they did, we could see suppression. The most interesting of the three, though, is he called the Clinton sock draw thing. And what that's actually referencing is a case called Judicial Watch v. National Archives, where Clinton declared 79 tapes from his own records, from a historian interviewing him, to be personal, not that of the president. And what Trump is saying is he has the ability to say when a record is personal versus official, and if it's personal, therefore he didn't commit any of the crimes. That's probably the most interesting of the three, Christian.
I'm glad you're here to kind of parse out, what's a political argument and then what could potentially be a legal argument. And clearly there may have been some preview there in his speech. Given what we know so far, what kind of motions might be on the table for the former president's defense to really challenge the prosecution's case?
There's three sets of motions you should expect. What happens first is the prosecutor needs to give over what's called discovery, all of their evidence. The first set of motions is going to say, you didn't give me all the evidence. I want this and I want that. And then the judge is going to have to rule whether they're entitled to this and that. The second type of motion is going to be a suppression motion. It's going to be saying, hey, listen, that Fourth Amendment, unreasonable search and seizure, your subpoena's bumped, suppress the evidence. Then the judge is going to have to rule on that. The third type is going to be a motion to dismiss. These are personal records. These aren't official records. Look at this Judicial Watch v. National Archives, the Clinton sock case. The problem with that is there's also an appellate case called Armstrong v. Executive Office of the President that says, hey, the president doesn't have that type of authority. So that's going to be an interesting ruling. And I'm going to tell you, I think that one will probably be appealed to the 11th Circuit. So we're going to have these three types of motions and then lots of appeals. And that's going to take a lot of time, Christian.
Yeah. The last thing I want to get to, Andrew, is the I want to talk about the special condition laid out in Trump's arraignment. He's barred from talking to witnesses about the case, which includes Walt Nauta, his co-defendant. How is that enforced? And what happens if the former president is found in violation of that condition? Not saying that there was anything untoward about, his visit to a restaurant, but he's with Nauta, he's around Nauta. How is that enforced? And what happens if he's in violation of that?
I'm going to give you my superficial reading first, and then I'll give you some substance. Superficially, it's spitting on the judge's face to go have lunch with the guy you were just told not to talk about the case with. It just was a bad look, and it's something Trump likes to do, walk on that edge of fire and see if he gets burned. But it wasn't a technical violation. The bond is out. You can go read it. You can go on the PACER system. And what it says is that the condition is that the prosecutors or the DOJ are going to list a number of witnesses, and Trump cannot directly talk to them about the case, but the attorneys can talk between each other. Nauta's obviously going to be on the list, and that's going to be someone we're going to be concerned about. If Trump violates that, there's all sorts of penalties, starting with his freedom. There's money penalties. It's on the bond itself. But Christian, I think the most interesting thing about this isn't just that requirement. It says on the bond that Trump can't get any crimes, no federal crimes, no state crimes, no local crimes. And as we know what's going on in Georgia and where it's going on elsewhere, he has to be squeaky clean or this bond's going to be revoked and he's going to be back in custody.
Yeah. As both sides build their cases against each other, we are building our knowledge base for what we could see going forward. Constitutional attorney Andrew Lieb, many thanks for being with us again.
Anytime, and thank you so much for having me.